100 word per minute dictation starts in 3 seconds. Sri W.H. Khan, learned senior advocate appearing for the appellant in Special Appeal number 449 of 2011, contended that the order of District Inspector of Schools was liable to be set aside. Stop. He submits that there being two rival claimants regarding election of the Committee of Management dated 31 October 2010, the District Inspector of Schools had no jurisdiction to adjudicate the dispute and was obligated to make a reference to the regional level committee in accordance with the government orders dated 19/12/2000 and 20 October 2008. Stop. He further submits that the order of Honorable Single Judge dated 1 December 2010, by which this court directed the District Inspector of Schools to re-examine the matter, cannot confer jurisdiction on the District Inspector of Schools, which was not otherwise available to him, and the District Inspector of Schools ought to have considered the question as to whether he was competent to decide the dispute or reference to regional level committee was necessary. Stop. He submits that the order of District Inspector of Schools dated 11/2011 deserves to be set aside by Honorable Single Judge, and Honorable Single Judge erred in not setting aside the said order. Stop. Para change. Shri Shashi Nandan, assisted by Shri Arun Kumar Singh, appearing for the respondents, submitted that the District Inspector of Schools had full jurisdiction to decide the dispute. Stop. He submits that according to the government order dated 2010-2008, the District Inspector of Schools has been conferred with the jurisdiction to determine the claim of elections of Committee of Management, and the order dated 11/2/2011 was well within his jurisdiction. Stop. He further submits that the writ petitioner and did not raise any objection to the jurisdiction of the District Inspector of Schools when the matter was being heard. Stop. He further submits that in the writ petition filed by the writ petitioners challenging the order of District Inspector of Schools dated 3/11/2010, no ground was taken that District Inspector of Schools had no jurisdiction to determine the dispute. Stop. He submits that in view of the directions of this court dated 1/12/2010, the District Inspector of Schools has to determine the dispute and write petition in not stopped from challenging the jurisdiction of District Inspector of Schools. Stop. Para change. The submissions of learned counsel for the parties center around to the issue as to whether in the facts of the present case the dispute of rival claims of management could have been decided by the district inspector of schools, or it was necessary for the district inspector of schools to refer the dispute before the regional level committee. Stop. Before we proceed to examine the above issue, it is relevant to note the relevant provision of the UP Intermediate Education Act 1921 as amended from time to time, as well as the government orders issued by the state government. Stop. The district inspector of schools under the statutory provisions of the UP Intermediate Education Act 1921 and under the UP High School and Intermediate College Act 1971 had to perform various statutory functions in collaboration with the Committee of Management. Stop. Para change. The trial court, on the basis of medical evidence, held that death of Seema was homicidal. Stop. As to the culpability of the accused for an offence under section 302, the court held that in the light of the evidence of father and mother of deceased Seema, it was clearly established that the appellant mother-in-law of the deceased was harassing Seema. Stop. The trial court also observed that it was true that in the first dying declaration the deceased did not involve her mother-in-law, but it was because of the fact that she was asked by her mother-in-law not to implicate any member of the family of the appellant. Stop. The trial court noted that after the first dying declaration was recorded, the parents and inmates of deceased Seema had reached the hospital. Stop. The deceased could not get courage to state true facts, and again the special judicial magistrate was called and the second dying declaration was recorded, in which she disclosed true and correct facts. Stop. Para change. The trial court also noted that the special judicial magistrate was conscious of the fact that in the first dying declaration she had not involved any family members of her in-laws. Stop. A specific question was therefore put by him as to the reason why she had done so, and the deceased had replied that it was because of her mother-in-law who asked the deceased to do so. Stop. The trial court therefore held the conduct of deceased Seema as natural and the second dying declaration reliable, which could be treated as basis for holding the appellant guilty. Stop. The trial court also observed that from the evidence of PW2, father of the deceased, and PW3, mother of the deceased, it was proved that Seema was ill-treated by her in-laws and particularly the appellant mother-in-law. Stop. The court also observed that PW5 had no acts to grind against the appellant. Stop. PW5 stated that on being questioned, Seema stated that she was burned by her mother-in-law by throwing burning kerosene lamp on her, but she had not stated so in the previous dying declaration because of the insistence of her mother-in-law. Stop. On the basis of evidence of parents of deceased, the trial court convicted the appellant. Stop. Para change. The learned counsel for the appellant contended that both the courts have committed an error of law in relying upon the second lying declaration. Stop. It was contended that the first dying declaration was correct and the deceased had stated true facts in the said declaration. Stop. It was also stated that after parents of the deceased had come to the hospital, they had persuaded the deceased to involve and implicate the appellant, and that is how the second dying declaration was recorded, which could not have been relied upon, and no motive was established by the prosecution. It was therefore submitted that the appeal deserves to be allowed by setting aside the order passed by the trial court and confirmed by the High Court. Dictation finish.